Thank you, Mr. Surabji, for a very insightful speech. Now we'll open the floor to discussion. So any students and faculty members who have questions can put forth their questions to the guests here. And Mr. Mitra will be acting as the moderator of the session.
Any query from the floor?
My nature of this question is not a question, it's rather asking, curiosity maybe. Article 19, Article 21, right to free speech, right to life, the entire text, Article 14, everyone has a right to equality. Now, before I present my curiosity, I must admit it's very much needed right now. But my curiosity is, what does this tell, or rather say, about the society which needs this thing to be written, just to be recognized, needs a community or like a section to interpret, to this, that, about these basic things. What does it say about the human society?
But as I said, this really provides opportunities. This proceedings and these judgments give opportunities to really enhance and protect the rights for the vast majority of Indian people who are illiterate, downtrodden and exploited. It's not an ideal situation. It's not an utopia. You may say it's utopian, but I think any map of the world which doesn't contain utopia is useless. For progress is the realization of utopias. Just consider what would happen without the judgments to these various people. As I said, I'm not talking of the captains of industry and the people who have 6 houses in 6 different cities in India. The vast majority of Indian people. So by this creative interpretation, the rights have been enhanced and protected. I think to that extent, it's not perfect. It's a step in the right direction, and I think we should see to it that this trend continues and we should consolidate.
Yeah.
Which year?
LLM, second semester.
No, LLM second semester.
Sir, I would like to ask first, suppose legislation tomorrow prescribes a right under Schedule 9, saying that you cannot challenge this right. So, what is the preparation required in order to challenge it, and how can you challenge it in the first place? If the legislation expressly prohibits that.
No, but it all depends upon what right is violated. That's why in Koido's case, they identify some articles as having the core values, 14, 15 and 21. So take a case, I mean it's not likely to happen. Suppose there's a constitutional amendment, only people belonging to community X can occupy this course. Practically changes our secular state into theocratic state. Now, what can be done is, you go to lawyers who would be willing to challenge this constitutional amendment in the Supreme Court, and they'll be very who do it pro bono, because this is onslaught on a secular fabric. You challenge it. But before this judgment, in Bharti's case, as explained in Koido's case, you would not be able to. That's a finish. Form and procedure complied with. Requisite majority in both the houses, it is ratified, you can't challenge. Now you can, of course. All depends on the particular legislation and the grounds we make out. The court may or may not agree. But the possibility is that this won't pass muster if it infringes the basic, damages the basic structure of the Constitution.
Can I just quote 226 of the Constitution, where you can challenge it before the High Court? You have Article 32, which is itself is a fundamental right, where you can challenge any digression. And as has been laid down in Keshwananda Bharati, 13 judges, and then in Coelho's case, 11 judges. These matters are now binding on everybody in India under Article 141.
And I forgot to, which Dr. Ambedkar described as the heart and soul of the Constitution. Because under Article 32, you can approach the Supreme Court directly if there's a gross violation of fundamental rights. You don't have to go to one High Court, single judge, division bench, and thereafter. But of course, I'm sorry to say some judges of the Supreme Court gone to really take the trouble of saying and say, go to the High Court first, go to the High Court first. So that's not correct.
Ayushi Singhal, and I am in second year of the LLB course here. I wanted to ask the role the ideology of a judge plays in the decision-making process. A recent example could be the Rajasthan Panchayati Raj Ordinance. Even when every one of us would agree that the Supreme Court must have taken up the decision and not sent it back to the High Court, and the High Court also completely disagreed to get into the matter since the elections were just about to come. So this all depended on the ideology of a judge, and I wanted to ask your comment on the same.
No, you're quite correct. All depends on the thinking, mindset of the judge. We all know in certain courts, in landlord-tenant disputes, the judge always thought the landlord was wrong. So there's no need to be senior counsel. In other matters, some judges are conservative. I'm not saying anything about the integrity. It's the outlook. Some judges do feel, well, let me decide to the High Court first. High Court knows the local conditions and then come. So, particular decision cannot be the basis for challenging the principles underlying the law.
So my name is Sanchari. I study in the 5th year. I study in the 5th year, sir. So my question is, you're discussing expansion of fundamental rights by judicial interpretation. My question is, sir, when does it cease to be judicial activism and become judicial overreach? So in this year, we were in a course, we were discussing the right to housing, and we were discussing Olga Tellis, wherein the right to housing, which can be more appropriately located in part 4, was brought into part 3 through livelihood. So if the state does not have the resources to provide this right, would it amount to judicial overreach on part of the judiciary to read this right into part 3?
Well, I think any order that the court would make would of course be qualified by the faith within the limited resources of the state. For example, right to employment. 10 million people will come ask for writ of mandamus, give us a job. So the judges will also realistically construe these guarantees and give proper reliefs. It can't be that the relief which you ask for is not capable of being granted from the very nature of things.
May I just add again here something?
Oh, please. I have the honor of having Justice Kabir as my brother judge.
There's just this, that since you mentioned Olga Tellis, let us try and understand what Olga Tellis was about. It was about people who had come and occupied the pavements in the city of Bombay.
Pavement dwellers.
Pavement dwellers case, as it is called. Here, initially, that question of locus standi was sought to be considered, and it was held that yes, a person, a citizen, having somebody else's good in mind, group, could maintain an application. Now, what was it all about? It was about these people who were living on the pavements, and they were also helping in the economy in the sense that they were working in different houses and in the other parts of the companies and which factories which were there. What was directed? That they provided for, in terms of Article 21, they provided an alternate shelter. It could be that the pavements had to be cleaned, because that was also a civic duty. And so they had to be shifted out, where they would still have access to their workplaces and at the same time would have the required shelter. So it was something within the means. One cannot, just like Mr. Surabji pointed out, one cannot just give an order without having a backing. I'll give you one example. I think I've spoken about this matter in other places as well, within the precincts of the university, where in Bihar there were about 37,540 primary seats vacant. Here, the question was of filling up the vacancies, not a question of providing them or putting any pressure on the state. These vacancies existed. So directions were given. We gave directions after finalizing the list. Today, almost all the posts have been filled up. So it depends, and of course, one has to keep in mind the economic resources of the state as to whether a direction. And I genuinely feel that the Supreme Court has oil in the High Courts. They do not give orders which are incapable of being implemented.
Ruling of Keshwananda Bharti, and it is well known that by virtue of this ruling and several others, there are some principles now which cannot be abridged by virtue of legislative action. Sometimes I wonder that what is to prevent a larger bench of the court from overruling this principle in future? Would that be inconsistent with the principle itself?
Going on. They require 24 judges.
I'm a 5th year student here. I wanted to ask you, sir, that with regard to the doctrine of basic structure and its various elements, how good is it to have these, to have the doctrine, not have any limitations to that doctrine per se as to what all can be added, what cannot be added? As in, it's a very fluid doctrine per se, and none of us have a clear-cut picture as to what exactly are the various elements that are part of it. I mean, as the various cases have gone on, there have been new elements that have been added. So,
but actually, today the judicial consensus is democracy, federalism, equality, judicial review by independent judiciary, and then one more, secularism. These are the essential features of the Constitution. If they are so infringed so as to affect the basic structure, damage the basic structure, then of course the Constitution amendment will also be pronounced to be unconstitutional. You know, we can't get clear-cut answers. We are not in a class. It all depends. Judges are, they will pass orders which are pragmatic, which Justice Gavi pointed out, capable of implementation. No use getting into a confrontation. No use passing orders which really from the nature of things cannot be complied with. And in Olga Teres' case, Judge, what has happened is they were sought to be forcibly evicted.
That's right. That's what is changed.
Forcibly evicted. Therefore, the court said, well, don't do that till you provide alternative.
You know, as far as the basic structures are concerned, they concern what the Constitution, what the essence of the Constitution is. They concern matters which cannot be tampered with without changing the character and the object of the Constitution. You will find it all there in the preamble. You look at the preamble: justice, liberty, equality, fraternity. Justice, social, economic, political. It says everything. Liberty of conscience, expression and belief, that's right. All these are again found there in the Constitution, and you'll find it all in Part 3, partly in Part 4, partly in Part 4A. You will find it all there. Nothing will change, nothing can be done by the legislature which can change the very concept of what was intended by the framers of the Constitution.
And I'm a 5th year student. So you have been an advocate of interpretation of the Constitution of the fundamental rights that benefit the underprivileged sections of society. Now, sir, there's a wide gap between the pronouncement of judgments and actual implementation. So what remedy do you...
Sorry, between not get
So,
last sentence.
So there is gap between the implementation and the pronouncement of the judgment. So in this case, what remedy would you propose? So is a stricter interpretation of Contempt of Courts Act enough, or do we require something else?
But actually, the Supreme Court directions are not carried out. Contempt of court proceedings is the most well-known and effective way of getting them implemented. But I can tell you, it does not really happen. Sometimes some clarifications require qualification. I'm happy to say, in our country, at least when I was Attorney General, the government never took the view, we consider it wrong, we won't do it. maybe approach the Supreme Court for some modification. But no, Supreme Court judgments have to be obeyed, otherwise there's a complete breakdown of the rule of law. That must be made very clear. It may be one way or the other, but no, the principle must be there.
At a future date, our country feels that we want to adopt a new constitution. Let's say that we want to move towards the presidential form of government. Now, according to the Indira Gandhi judgments, the parliamentary form of government is part of the basic structure. So would not the basic structure stand in way of maybe changing our constitution in a way that fits our future needs?
I'm not too sure whether the majority has said that parliamentary government is a part of the basic structure or an essential feature. This is debatable. But why don't you do this? Even when they do it, we'll meet again and decide.
There is one way, revolution. Revolution.
Vijay Kumar, I'm the faculty here. Sir, just I want your personal opinion and views that currently so far in the preamble that we have the two terms, that is socialist and secular, which have been added. Recently there is some controversy. One view is that let it be removed, or the other is let it be there. Now let it be there, if you say yes, it has to be there, then of course I do understand something about the term secularism. We follow it also with constitutional provisions also. What is happening about so far the socialist? Because we are talking in the preamble socialist, but in practice we are finding everything is going to be in capitalist hand. So what is your take on that one? Should we done away with all these two terms, or should we keep these terms in the constitution?
Well, these terms have been added by constitutional amendment. Actually, secularism in a way would be a corollary from Article 14, because we treat all equally. But socialism is debatable. But why this is debate? It's been passed by the constitutional amendment. And what harm has it done to the country? In the preamble, real thing is bring out a socialist way of life for the people to improve. I don't understand sometimes politicians who don't know the constitution at all talk like constitutional pundits, and that's what the problem arises.
Thank you very much for the questions, and I'm sure that you are happy with the answers which have been given, not only by the Attorney General of India, but also one of the Chief Justices of the Supreme Court of India. Now we shall move on to the next program.
I now invite the Honorable Vice Chancellor to felicitate Mr. Sorabji as a mark of our gratitude.
I really treasure this and cherish it. Thank you very much.
Send our journals and the book on constitutionalism and constitutional pluralism to Justice Altamas Kabir.
Thank you.
I now invite Honorable Justice Kabir to come.
Well, I'm on the dais. Anyway, apart from that, I'm very much a part of the university now. So, first of all, our former Attorney General, Solicitor General, and one of our widely respected advocates of the Supreme Court, respected not only in India, but even outside. I'm glad that the Vice Chancellor requested him to be the person who could deliver the 8th D.D. Basu lecture endowment lecture today. Advocate General Joyanta Mitra is known to most people who are in Bengal. I don't know why he was shy in coming to the Supreme Court once in a while, but I did see him sitting in the bench where I used to sit, and I had to take special care to see that he could go home as quickly as he could. Vice Chancellor, he has been doing a lot of good work since I've come here. Dr. Ashwatthana Basu, the son of, I don't know how one calls him, do we call him Justice D.D. Basu or just D.D. Basu? He is one of those persons whose names can be conjured with in the field of this concern. To us, his shorter Constitution of India, when he used to practice, was almost like a Bible. We used to carry it around with us everywhere, like the CPC, the CRPC, the Evidence Act. These things were like the very foundations of the different jurisdictions. And I'm extremely happy that D.D. Basu lives today not only through these programs, but by virtue of his books, which are being published and republished. Today we heard a person who has dealt with many, many important cases with regard to fundamental rights, which I say is the same as human rights. There's nothing different between fundamental rights and human rights, except that the Supreme Court has, by interpretation of Article 21, has also included basic human rights. Basic human rights which every person who is born has a right to have or to enjoy. Like I say sometimes, a baby when he is born or she is born, she's born or he's born with a right to be able to breathe fresh, unpolluted air. This is a basic human right, plus it's a fundamental right which has been interpreted by the Supreme Court under Article 21 to mean a right to be able to grow, live and enjoy life in dignity. A human being has a right to live in dignity, in human dignity. I often say that a baby, a human baby, when it is born, takes at least about 2-3 years before it can do anything for itself. Babies of the animal world, they don't need, even at times, not even 2-3 seconds. That is the basic difference between basic human rights and animal rights. Those you, I may have said this before, maybe some of you have heard this before. If you have an aquarium and you have these little fishes, mollies, black mollies or the red swordtails, if you watch them, they give birth directly to their babies and they don't lay eggs. And as soon as the baby is free, it starts swimming and looking after itself. These are the within seconds examples. Any animal, say a calf, if any of you watch the Discovery Channel or the animal, the channel which shows animal pictures, Animal World, that's right. And you can see children, the animals being born, and within matter of minutes, they're up and about and roaming around, even maybe nibbling at a few bits of grass. This is the difference between human babies and babies of other the animal world. So these human rights are so interwoven with everything that a human being needs or needs to do. It becomes so much more important. Part 3, all of you know, contains the fundamental rights. Part 4, I'm glad that Mr. Sodi Surabji, very affectionately we all refer to him as Sodi. So sometimes it's a bit of a slip of the tongue. But I'm glad that he touched upon the provisions of Part 4, that is the directive principles of state policy. Whatever was intended in Part 4 was intended, Article 37, that these rights cannot be implemented or enforced by a court of law. But it also says that these are the guidelines for good governance. As a result of which, Article 39, which deals essentially with people who are indigenous, indigent, those people who cannot, who are in economic difficulties, they cannot enforce all their rights. It is to keep those people in mind that various enactments have taken place. That will be, it will take too long to go into. It will be another lecture. But one good thing did come out, and that which Mr. Surabi mentioned was about the fundamental right to education. As all of you know, Article 45 provides a very small little sort of a guidance that the state must look after the education and needs of children between 0 to 6 years. But that is only directive principle, and that really did not cover the field of education as such. So, you have Unnai Krishnan, you have Mohini Jain. As a result of it, these Supreme Court decisions, which converted or which compelled the government or the legislature to convert that right under Article 45 into a fundamental right under Article 21 capital A. This is how the Supreme Court has worked. Even the things relating to Keshwananda Bharati and the Coelho cases, what are they? They seek to protect. They are always in aid of the Constitution, not against. They are in aid of anything which the Constitution needed to be done. And if these principles are to be challenged, these doctrines are to be challenged, I don't think it would be, first of all, very easy to do so, because the matter has been gone into in great detail. But in case, if it ever comes up, well, at that time one will have to see whether any of the basic features can at all be tampered with. You know that Article 19(1), was it G? F, right to property. It was a fundamental right, but this was one case where, on account of the keeping in mind social reforms as far as land reform is concerned, it was taken out from 19(1)(f) and made a constitutional right under Article 300 capital A. This is one of those rare examples, but that was also for the purpose of social, in forwarding social reforms. There's one more thing I'll just touch before sitting down, because I don't think there's really much more to say at the present moment. That is, Soli touched on a very raw nerve of the Supreme Court, a raw nerve of all of us in the who were there in the Supreme Court, and that's the ADM Jabalpur case. It was a decision which everybody has a problem with, and I must say this to the, although it is against judicial discipline, two judges of the Supreme Court sat, and one of them commented in the judgment itself that ADM Jabalpur, though passed by delivered by a larger bench, was not correct law. I don't know whether you know about this, but this is something which the Supreme Court realized and tried to correct itself. But it still is a two-judge bench observation, and nothing more than that. But in any event, I think most of us now understand what the constitutional principles are. I've had occasion to deliver several judgments with regard to that common man at the grassroots level. The Supreme Court had, in one case, taken an innovative measure. It has taken many innovative measures. The Bhopal gas tragedy. Recently there have been so many orders that have been passed. 18 units, blocks around the Bhopal, the Exide factory, the Union Carbide factory, have been affected because of the cyanase, which was oxide, which was released in the factory. The water level, the ground level water, or this water has been contaminated, as a result of which these areas, they cannot use the water, groundwater, for drinking or for any purpose. We had to pass orders so that this was all by virtue of Article 142. We passed orders so that pipelines could be laid to each house, each having their own taps. These are measures which the Supreme Court could take and pass. These are orders which the Supreme Court passed in the interest of the people who were there. There was one case which went from here, from West Bengal, to the Supreme Court, which involved the murder of a prostitute. It went up to the Supreme Court, it was admitted, and the matter was pending when the convict, appellant, died. What would have been the natural course of events? If I was to be very legalistic, what would I do? I would record the fact that the appellant was dead and the matter has come to an end. The Supreme Court didn't do that. This is where the Supreme Court plays its role of looking after the people of this country. What did it do? It converted that particular criminal appeal into a public interest litigation, where the committee was ultimately set up to look into how prostitutes who wished to leave the profession or who wanted to be rehabilitated, who had been forced into the profession, how they could be rehabilitated. A committee was set up, number of reports were submitted after they had visited the various places, and the 7th report was the report which he ultimately accepted. But that is still pending, the matter is still pending. Look at it the way it was handled. Criminal appeal turned into a PIL for the purpose of resettling and rehabilitating sex workers. That has been the approach of the Supreme Court in most of the cases. Yes, we have been legalistic in some. It depends on the person's view, basically. Whether when I'm sitting there I look only to the letters of the law, or whether I look a little beyond that. But the Supreme Court has, by and large, my experience has been, by and large, it has always tried to look after the rights of the citizens of this country. Come what may. I'm so happy that, sorry that you were able to come here, and you were able to deliver this lecture to us, to all of us. It was a pleasure to hear you. It was a pleasure to hear the advocate. And I guess we will be having many more sessions, both faculty as well as the students. And I must say one thing about our students. I was told when I initially thought of coming here, be careful, the students are very rough. They'll badger you and things of that sort. Believe me, that is absolutely not true. These children are lovely. The students are really good. Thank you very much.
Thank you, Justice Kabir. We will now distribute the prizes for the 3rd Durga Das Basu essay competition. To mark the birth centenary of Justice D.D. Basu, the university brought out the book Constitutionalism and Constitutional Pluralism, authored by Professor Dr. P. Ishwara Bhatt. It was published by LexisNexis. From the royalty and interest earned from this work, the university has instituted prizes for the 3 best entries in the competition. We request Mr. Shaudendu Basu to hand out the certificates and prizes to the winners in the NLB program. The second prize has been secured by Sayashi Saha, who is a LM student, but she's not present here today. So, the third prize has been secured by 2 students. The first is Vageesh Sharma of the 2nd year. Pradyumna Soni of the first year. Request the Honorable Vice Chancellor to deliver the presidential address.
Esteemed Chief Guest and Scholar who delivered Eighth Durga Das Basu Endowment Lecture, Honorable Justice Altamsh Kabir, Honorable Advocate General Mr. Jayant Mitra, Mr. Sharvind Basu has come all the way from London, members of family of Dr. Durga Das Basu, esteemed colleagues, friends, students, ladies and gentlemen. It gives me great pleasure in expressing my view in this occasion. First of all, let me thank Mr. Soli Sorabji for delivering a wonderful lecture on expansion and protection of fundamental rights by judicial interpretation and intervention. He has covered the whole expansion process that took place from A.K. Gopalan to the present. What was the approach of the court? What was the philosophy that influenced the court, and how it expanded the scope of various fundamental rights? About this, he gave a very valuable lecture. In fact, he was pointing out every now and then that it is look to the reality, look to the social reception, social effect, look to the effect upon the society or impact upon the society. What he was pointing out was that instead of looking from the angle of that ivory tower approach of a theory of separation of powers, which so many other jurisdictions have deified or glorified, the Indian Supreme Court's approach, which has helped the cause of a common man, that is to be taken into consideration without resorting to for the constitutional amendments. How nicely the Supreme Court evolved number of new rights, deduced new rights, so that the interstices could be filled up with a new approach, new device, new idea, so that the rights of the people at large could be properly evolved by that process. That is a wonderful contribution of the judiciary. The interpretation and intervention was mainly by looking to such interstices or such gaps and mutual relation amidst rights, mutuality of assistance as well as a mutuality of balancing of rights. These are the two factors which made the court to evolve those new rights. Expansion of these new rights took place, especially in landmark cases like Neelavati Behra, Vishakha, or Keshavananda and other cases, mainly by looking to these aspects of mutuality of assistance and mutuality of balancing amidst these rights. The philosophy of rights or the influence of international human rights principles, conventions, that had cast its own impact upon the constitutional jurisprudence, and even during answering various questions posed by students, he was pointing out that in spite of some of the limitations, these rights come to the help of people. So we have to look from the angle of the sociology of the constitutionalism. We have to look from the angle of the way in which ultimately the rights come to the rescue of the people or come to their protection. That's a wonderful analysis, because expansion has taken place to help the cause of a common man. That's a very important thing that I have to remember. It is not just a narration of the whole of the Supreme Court's approach. How ultimately it is the society which got the benefit. Actually, he starts his lecture from the Tilak Bill or the 1925 Bill, Anniversary Bill, Nehru Committee report. What were the aspirations behind all such efforts? The aspiration was to help the common man. And in this task, the judiciary has by and large succeeded, and the analysis made by Soli Soraji is giving emphasis on that aspect. We are quite fortunate to have his lecture here. In fact, for all the earlier Durgadas Basu lectures, we had the opportunity of having very eminent scholars. It was started with Nariman's, F.S. Nariman's lecture. Then, of course, M.N. Venkatachalaya and various other scholars. Mark Testnet, then Dr. Green, and of course, Mr. K.K. Venugopal, Rajendra Babu, of course, other very eminent scholars had delivered such lectures. And last year it was Honorable Justice Anand who delivered a very thoughtful lecture. And this edition is something actually making our annual exercise intellectually fascinating, and this is a very important addition to the whole series of Durgadas Basu lecture series. And on behalf of the university, I am expressing gratitude to Mr. Soli Soraji. Of course, Sharabinda Basu was quite helpful in all of these things. In fact, the very formation of this endowment by Basu family is something that enabled this kind of exercise, and he has been generous, and this year also he helped us, he assisted us, so that the assistance will be maybe for travel and other expenses, and even the centenary volume that we had brought out, that has helped organizing this competition, essay competition. I'm quite happy that students have participated in a full spirit and good numbers for essay competition. And today's endowment lecture is also something participated by number of students. I'm thankful for making this event a grand success, and I'm thankful to Mr. Jayant Mitra also.
Thank you, sir. Now I invite Shamik sir to come and deliver the vote of thanks.
Thank you, Shohini. First of all, before I deliver the vote of thanks, may I request the Vice Chancellor to kindly present, as a token of our gratitude, copies of our journal to Dr. Shorbindu Basu. May I also request Professor Bhatt to present a memento as a token of appreciation to Advocate General Mr. Jonathan. Now let's formally conclude the session with a vote of thanks. Of course, first of all, Dr. Shorbindu Basu, without whose generous endowment, the D.T. Basu endowment lectures would have been a mere dream for us. He has flown down from London. He has spent considerable amount of his busy time in helping us organize a lecture, and we express our gratitude on behalf of NUJS to you, sir. Mr. Soli Sorabji, today's speaker. Well, as a constitutional teacher, at least personally I can say that things that I am not able to cover over the course of 2 semesters, 2 long semesters, Mr. Soli Sorabji has so efficiently covered a vast trajectory of intriguing constitutional issues over the course of just about half an hour. That speaks volumes of your greatness, sir. We are grateful to you. Mr. Joyanto Mitro, our chief guest for the occasion. We are really sorry, sir, that you got out for a dark, but trust me, your presence here was intellectually and personally very stimulating for us. Thank you very much for coming, sir. And finally, Honorable Justice Altamas Kabir. We should now formally start calling him Professor Kabir. Professor Kabir is very much a part of us. No words of thanks, no words of gratitude is enough for him. Thank you very much again, sir. The Vice Chancellor, Professor Bhatt, once again pulled off the lecture at a time when there were a lot of infrastructural hurdles, but the amount of ease with which he pulled off this lecture was amazing. Thank you, sir. The Registrar, Dr. Parameshwaran, all my colleagues, the Constitutional Law Society's students, the Law Review students, all the students who have come, who have attended this lecture, the guests, other dignitaries, big word of thanks for all of you. Thank you very much. Thank you all, sir.
I request all of you to kindly stand for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाहे तब जय गाथा जन